free to submit them, and I'll see them come up and I'll answer them as they come up. And then also at the end of this webinar, you'll get an email about some feedback forms and a place where if you'd like us to reach out to set up an initial consultation, along with some other materials that I'm going to go through. Those will come out to you at the end of this. And in terms of our initial consultations, we offer complimentary consultations scheduled for about 2 hours to give us enough time to go through everything. But again, we want you to come in if you have questions and need some assistance with this type of stuff. So those are complimentary. And then before I forget going too much into it, our topic next week is actually going to be about common, just general estate planning myths. Things that people might have heard about wills and trusts, or what you should and shouldn't do with those types of things, or what the internet says, right? So that'll be a really helpful kind of overall overview for people too. Okay, and then the material I mentioned is common errors that people tend to commit when they're helping aging parents. So I'll go through some of these too, just kind of part of the nature of what we're talking about, but it's a really helpful tool to just if you're trying to get a sort of quick breakdown on what you maybe shouldn't be doing in the event that a parent needs care. Okay, so to get started, when we're talking about somebody needing care soon, we're really referring to long-term care, meaning, maybe they need assistance at home with like a couple hours a week, someone coming in, maybe they need assisted living, or skilled nursing, depending on their health, right? So that type of care is what we're talking about. We're not really referring to like if they just need medical treatment in the hospital, things like that. I mean, there's other considerations with that, absolutely, but not the types of considerations that you would have going into a facility for long-term care, potentially. When we look at what we maybe need to do planning ahead for those things, there's some sort of just general advice in terms of practical things that you want to start to do. And then there's the legal side of it too. The practical stuff, a lot of this is stuff that you'd probably be already trying to do at this point, getting together financial statements, figuring out the advisors that your parents or loved ones work with, so you know who to talk to about these sorts of things in terms of what types of investments they have or how much they have. That kind of stuff is just sort of the practical side of what do you need to begin to plan for a loved one who is going into care. Those are the things information-wise that we would need, for example, to do that planning as well. It's very important that we know what does somebody have, what types of assets are we dealing with if they're about to go into care, do they own a home, things like that. It's very important so that we know exactly what we can and can't do, or what we can help them protect potentially going into care. And then the legal side of what you should know about, really, this is the main focus of today's discussion, but in general, a lot of things that people are told when they're concerned about parents going into care, or maybe the parents themselves were told incorrectly. A lot of these things are dangerous in terms of the consequences of what can happen, right? So one of the biggest myths that people run into when they're planning for long-term care is they think there's this amount that they can give every year where, okay, if I stay within that amount or I don't go over that amount, it's not a problem, right? I can do this much per year without having a problem for needing care. And what I mean by not having a problem is when we talk about long-term care, a lot of times we're looking into Medicaid for somebody after they've spent through what they're allowed to keep when they apply for Medicaid. So that amount varies depending on whether they're single or married. But when people are gifting, they're trying to protect assets, help themselves get down to Medicaid. The problem is there is no amount safe haven-wise in terms of gifting that is expressly authorized to get around the divestment that you'd be creating for Medicaid. And with Medicaid, what a divestment is basically if you gave something away, you sold the home for $1, right? You gave somebody a sweetheart deal on something, or you tried to hide things, right? That's where that divestment comes in. If you then apply for Medicaid, they will look back 5 years, which is where that 5-year rule comes in. And if you did any of those things in the 5 years, based off of the value of what you gave away, that's the amount of a penalty, or that's how they figure out how much your penalty period is. And it's not a dollar amount that, oh, pay us back or else. It's here's the number of months that we won't provide payment. Medicaid won't provide payment to the facility because of how much you gave away. So the amount that people are talking about when they say, I thought there was some amount, is the gift tax exclusion, which this year is $16,000 per person, per everybody you know. So I could give $16,000 to everybody I know, and I wouldn't have to file a gift tax return. The problem is that is for gift tax purposes and estate tax purposes. It has nothing to do with Medicaid, and Medicaid doesn't care that exemption exists for the gift tax side of it. They're different rules. So where people run into issues a lot of times is they've been doing this thinking they get around that 5-year look back because, I thought I was within my amount. Well, unfortunately, if you've been doing that, that can be a problem. There are some exceptions to certain things, but for the most part, if you were doing it, consistently, or especially within the couple years before you need care, that's a big problem. And it's something you need to be aware of. It would be something that would create a divestment for Medicaid. So gifting is something that can be very dangerous if you're doing it without getting advice on it first in particular. I mean, there are definitely times where that may be involved in protecting assets for somebody, but you definitely need to talk with somebody who does Medicaid planning, who knows the rules before you're engaging in it, because a lot of what you read on the internet is not only wrong, but is not written by legal experts on the matter either. It's written by, somebody who maybe heard from somebody that it might be a good idea, right? So it's very dangerous to rely on that without talking to somebody, local who can help you with that. So gifting can be a really big concern when it comes to doing it sort of without a structured plan in place or knowing what the rules of Medicaid are. But in general, there may be better ways to deal with things too. So another big issue we run into a lot is when somebody needs care, a lot of times their big goal is to stay at home, right? We want to stay at home as long as possible because of the independence involved. Nobody wants to go, generally speaking, into a care facility, not because they're not nice enough or anything. It's just we like our homes, right? We lived our entire lives there. It's what we own. It's familiar to us, so we don't want to leave if we can help it. But when you're talking about staying at home, a lot of times it becomes an issue of, well, how do I make sure I'm taken care of then? What happens if I need assistance? And people will often pay, their family members to provide assistance to them. This doesn't sound like an issue because it's not even really a gift at that point, right? You are paying somebody to help you, and it's a fair market value exchange at that point. The issue is that Medicaid presumes that any payments to a family member for care at home is a gift. So if you or a loved one are providing care for a loved one who may need care soon, it may get to that point where they actually need care in a facility. It's really important that you actually have a certain type of agreement in place in writing, and that is notarized. It's called a Caregiver Agreement. And that agreement is very important because then if Medicaid tries to say with that application that, hey, you were gifting all this money away, where was all that money going? The person, can show them that agreement that says, look, we were just following this agreement. They were providing X number of hours of care at this hourly rate, or at whatever rate is agreed upon, and it was notarized. And the other caveat to that is the person receiving that payment does have to file income taxes for that, right? It is taxable income, but that then makes sure that those payments that you were actually providing care were not a divestment, were not a gift for Medicaid. So especially where you are actually providing care or assistance at home, that caregiver agreement is essential. So another part of the big, what really dictates what we can do to help people a lot of times is what types of documents they have already from a legal perspective. So what I really mean by that is, do they have an irrevocable trust already that maybe they've set up years ago for long-term care purposes? Do they have powers of attorney in place for finance and healthcare? The financial power of attorney in particular is very important to take a look at, especially if your loved one still has capacity to update it and see what it actually allows you to do. Get it looked at by an elder law attorney to see if it has the authorities that it needs. The big problem with financial powers of attorney is not the documents themselves as a general concept, but they are only as good as what is in them in terms of the authorities that they grant. So no two powers of attorney are necessarily alike. If one has very expansive authorities, it's going to allow that agent, that son or daughter or family member, to be able to help mom and dad a lot more through a lot of other means than like the state statutory form, which is the one you can just download. There are a lot of issues with that form because of how ambiguous or vague it is. It doesn't grant certain authorities that you would need to be able to engage in long-term care planning for a parent or a loved one. So where this is really an issue is if the reason somebody needs long-term care is we're starting to look at memory care issues, maybe Alzheimer's or dementia, some form of dementia, right? That issue with that is they may or may not have capacity to update documents. And if their power of attorney that they have, if they have one, doesn't allow for certain authorities that we would need to be able to maximize the protection of that person's, assets, if they don't have capacity to sign a new one, you're sort of stuck with what you have, right? There's no way to update it beyond that point. If somebody doesn't have a power of attorney, you can go through guardianship to get a lot of those same authorities, but the guardianship court is almost certainly not going to allow the same level of authority we would need someone to have to fully do that, long-term care protection planning. So there's no power in that power of attorney, no authority that would just be called like long-term care planning, but it's a collection of things. Like can my agent, my financial power of attorney, can they make gifts on my behalf? Are they limited in the amount of gifts that they can make, or can they gift as much as they need to do things? Can they set up certain types of trusts for me? Can they, file a Medicaid application, right? Those are the sorts of things that, as just not an exhaustive list, but some of the things we would definitely want to see in that financial power of attorney, so that if you or a loved one becomes incapacitated, we know whoever this person is can do what we need them to on your behalf or on that loved one's behalf. So you really need to look at the current documents or have them reviewed by an elder law attorney or estate planning and elder law attorney who knows what types of authorities that they need to know whether or not it covers your situation or what could become the situation in terms of long-term care. Really, I mean, it doesn't, if somebody has a power of attorney for finance that has all of those authorities that we need, it doesn't matter if they don't have a trust by the time they need care. They haven't done any planning before that. There's still things we can do to protect a certain amount of assets, even if they don't have 5 years. We just need to know what's in that document and know that we can do the authority or have the authority to do what we need that agent to do. There are unfortunately times where we're stuck because the document doesn't allow it. That person doesn't have capacity to sign a new one potentially. And again, the guardianship court won't necessarily grant all the authorities we need. So it's really important to do this ideally well in advance of ever needing care, but especially if you're concerned about care coming up soon and you're worried about needing those sorts of authorities, getting those powers of attorney up to date are essential for that, and having them looked at to make sure they have what you need. On the healthcare side of things, the healthcare power of attorney, just be aware that some facilities, depending on their certification, can't accept patients or residents, I should say, who have a declaration of incapacity. Now, skilled nursing facilities, some types of assisted living facilities will have the right certification for that, but not all assisted living facilities do. So when you're looking at where can mom or dad go, if there's been a declaration of incapacity by those two physicians, right, that can be an issue for some people in terms of that particular facility. So it's really important to know whether or not that power of attorney for healthcare actually requires a declaration of incapacity too, because not all do. So that's the power of attorney side of things is really what can the agent do to help plan for care. And so if somebody may need care soon, it's very important to know, one, where those documents are, what those documents allow, and who's named in those documents. So if you're the parent in this situation and you haven't talked to your kids or whoever you've named in your powers of attorney about them being named, it's very important that they know where these documents are, having copies of them potentially, and at least knowing they're named at all so they know what they need to do if you do need care. So that, the legal document side of things is actually very important when we're looking about what can we do to do this planning. It's very important to have these looked at. Okay, so one of the myths that we run into a lot too with this is that gifting the home is a good idea to protect it from care. And so when if you're talking about maybe needing care in the next couple of years, next 5 years even, or maybe a little bit beyond the 5 years, you're trying to get around that 5-year rule. Gifting the home comes up a lot as a potential issue, or a strategy, I guess, would be another way of looking at it. But there are a lot of issues with that strategy that can come into play. With gifting the home, the biggest issue is a huge loss of control, right? And now, hopefully, the person that it's now owned by when it's gifted won't do any of these things, but this is where you hear those horror stories about somebody, charging rent or evicting mom or dad from their own home, right? We want to protect against those sorts of things, because you don't want to protect it from your care just to have some other thing happen to you too. The other issue is with taxes. When you gift real estate over to somebody, you're also gifting, or you're transferring over whatever your tax-wise your cost basis in that property is. So if you own your home and you sell your home, how they calculate how much of a gain tax-wise that you have, what you'd have to pay taxes on, is the difference between what that cost basis is, essentially what you paid for it, and with some other adjustments. I won't go too much into that, but the difference between that and what it sold for. So if it's sold for $100,000 more than you bought it for, that's essentially the gain, right? Well, with your home, when it's your primary residence and you've lived there for 2 of the last 5 years, you are able to have basically an exclusion from capital gains of $250,000 per, like if it's married, it's double that, right? It's $500 for a married couple. So most of us, when we sell our homes, our primary residences, we don't have any sort of taxable gain unless there's been a very, very large gain on it. But when you gift it over to the kids, if they get whatever your cost basis was, and then they sell it, if it's not their primary residence, they don't get that same exclusion. So if you're looking to maximize the value of what that person receives from the home, especially from an inherited perspective, it's much better for them to actually get it through your estate plan, so through a will or through a trust that you're passing to them, than it is to gift it over, because then they get that adjustment and cost basis you may have heard of up to fair market value. So that can really help them avoid capital gains tax on that property. But really where the gifting the home is the biggest issue is you may protect it from your long-term care if you are well beyond those 5 years. But the issue a lot of people end up running into is that, well, now you've given it to other people, and those people also have their own potential liabilities. And you don't want to protect your home from long-term care just to have a son or daughter get divorced and have the home be subject to that, or for them to pass away in that home to be split up ownership-wise amongst their beneficiaries that you didn't necessarily anticipate having inherited. Or if they get sued for some reason or file for bankruptcy, right? That's not as protected of an asset for them as it would be for you. So you don't want to protect it from your care just to open it up to someone else's liability. So before you ever engage in that strategy of transferring the home to anybody or any trust or anything like that, you want to talk to an attorney who can help figure out whether that's actually a good situation for you to set up that way. But generally, that's where irrevocable trusts are safer options for that, because that protects against a lot of those uncertainties of like, what about the kid's liability? Well, with an irrevocable trust, they aren't the trust, so that doesn't matter, right? It still gets that step up in basis. There's protections for the resident of the home to make sure they can't be evicted, right? So that's where we tend to prefer that option for most people. One thing you may hear about, especially with the home, is what's called a life estate deed. This is essentially a deed where the original owner of the home has the right to reside there. They can't be kicked out. It transfers to the other kids right after they pass away. And as that original owner gets older and older, their percentage of ownership gets smaller and the kids gets larger. This used to be very common planning prior to a law change in 2014. It would, get it out of their name for, long-term care purposes. It wouldn't be available for Medicaid coming in later in the estate. But unfortunately, in 2014, any life estate deed that is done after August 1st of 2014 does not protect against that estate recovery side of it. So there are unfortunately still people out there giving advice on this, saying that they should do this, right? That will protect things, but it doesn't work the way it used to. If you have a life estate deed that's older than that period of time, it's prior to August 1st of 2014, then it's grandfathered in. So that's not as much of the issue as it is that the fact that there are still people out there doing life estate deeds post August 1st of 2014 and kind of implying that they're as protected as they always have been. It's not that somebody's necessarily trying to give bad advice. They just may not be up to date on the rules, but that's exactly why it's so important to talk to somebody who only focuses in these areas, as opposed to, somebody who maybe has never dealt with an elder law case before. Life estate deeds, we never really used them even before then, because there are better ways to do it tax wise and, in terms of control and, the ability to move and do all of those things and still get the full value back. I mean, there's always been issues with life estate deeds, but they in particular just don't do what people think they do now. With accounts and assets in general, when you're talking about, I mentioned caregiver agreements as an option for a lot of people for paying for care or providing assistance to somebody, and getting that person actually compensated for it. One of the biggest mistakes people make with their estate plans is they say, oh, I'll give them a larger percentage to, compensate them for that effort, or I will, give them this account to make sure I'll put it payable on death to that, beneficiary, so that they can, be compensated for what they did for me, right? And that sounds like a good idea until you realize that only works if that person actually has those assets left when they pass away, right? Part of the concern with long-term care is people spending down to such a low amount that they qualify for these programs, right? Medicaid has asset limitations. So for a single person, if you have more than $2,000 in available assets, that's you have more than Medicaid will let you keep. So in terms of compensating a loved one for care, that's where that caregiver agreement is much more important than making sure that happens than it is to say, I'm going to just leave you more of my estate, because that only works if there's an estate left to leave. If it's all been eaten up by their care, there's no guarantee that they will ever be compensated for that. So it's very important for that to be discussed as a family or as a parent and a caregiving child, to know, okay, what are we going to do to make this actually work the way we intended? And actually, as a general sort of piece of advice, another really good thing is to look at, discussing these things in advance. I mentioned getting statements together earlier about making sure people know about these things and know about what they need to do with the assets, who you work with, all of that. And there's an unfortunate, common problem we run into where nobody's ever talked about these concerns, right? The parents avoid talking about the estate with the kids because they don't want them to know what's in there. And that can be a problem when that child then needs to actually step in and handle things or plan around their assets for long-term care. You need to know what actually exists before you can, accurately plan. So if you avoid talking about these topics, it just delays the inevitable anyway, but also makes them much less prepared to step in and take care of those things if they really need to. So having these discussions early is very important. I always recommend inviting kids to, like, when parents sign these types of documents with us, if their kids want to join and they want their kids to join in those meetings, they're more than welcome to, right? Do the same thing with your financial planner. If you work with advisors on that, or your CPA, let them know who you work with. Or if you're the child in this example, ask your parents who they work with. If somebody's uncomfortable giving financial information right now, well, but if the financial planner actually knows all that information, even if they're uncomfortable with the kids knowing it right now, at least there's somebody there who can help them when the time comes. But even then, I mean, if these are people that you trust to be in charge of things and you want to help you, plan for your care if that comes up as an issue for you, letting them be aware of those things. I mean, if you trust them to step in that circumstance, that's all that should matter in terms of letting them know these things so that they at least know where to look for things. That's very important. Another sort of really big issue that we have with powers of attorney that people run into is they'll often try to sign their own names on documents. Like spouses do this all the time, where they sign each other's names for things. Well, you can't do that in general, really. You're not supposed to. But as a child, for a parent, you're definitely not supposed to do that, because that is technically forging their signature and is fraud, right? So that's where it's really necessary to have these powers of attorney to step in and deal with these sorts of concerns. And even as a power of attorney, just if you are someone's power of attorney and you've been doing this, just know that how you're actually supposed to sign your name as a power of attorney is you sign your own name still, and then just afterwards say that it's as power of attorney for that individual. I wouldn't sign my parents' name as their power of attorney agent if that's the capacity I was acting in. So when you're talking about, getting everythh together, the documents are absolutely essential. Knowing at least where to look for these things is essential. And knowing that there are things you can do is very important. I'm kind of cutting it close on time here, so I'll wrap it up, but I want to leave you with kind of, when we're talking about Medicaid and what people have to spend down to, give you a picture of what that actually looks like, because I think that's very helpful in terms of framing, just getting started. Okay, what do we even need to know about? So I mentioned a single person already. That's relatively straightforward. It's they don't force the single person on Medicaid to sell the home, but they will start to eat it up with a lien over time, where they can recover against it after the person's passed or if it's sold, right? So that can be an issue for that. In terms of other assets that they're allowed to keep, they can keep a life insurance policy or policies that total do not exceed $1,500 in face value. If it's over that, they'll look at the cash value as an asset. You can keep a car of any value. That's where I jokingly tell people, but don't actually do this, but I'll jokingly say, if you've ever wanted that Ferrari, now's the time to do it, because in theory, they don't care about the value on it. But again, that's not a good planning strategy. And then the other assets, that's where that $2,000 comes in. So anything else, other than like prepaid burial expenses, which is one thing I forgot to mention there. All of the other assets, so like retirement accounts, bank accounts, investment accounts, cash value of life insurance, total, that person can keep $2,000 and only $45 a month of their income. So that $45 a month of income particularly becomes an issue for a lot of people. For married couples, it's a little different. If one of the spouses is still, quote unquote, healthy, living at home, right? Not the one needing care. The spouse living at home gets to keep their primary residence. There's no lien placed on it for that. Their qualified retirement accounts, so like IRAs, 401ks, those sorts of things are protected from their spouse's care. They don't have to spend those down. Same sort of stuff with the life insurance, right? That $1,500 face value still is the available or the unavailable amount. Prepaid funeral expenses up to about $15,000 per person. And then the car as well. And then that $2,000 is not what the community spouse, one living at home, gets to keep. They actually have a range of what they can keep of all the other available assets. So after they take all of those protected things off the table, they pool the value of everything together and they divide it in half. And they say, if your half is the floor that you get to keep is $50,000 of that available amount, but the max that you get to keep is 138 roughly this year. And if your half falls within that range, it's whatever exactly that half is. So like if somebody had $200,000 of available assets, they'd keep 100, right? But if you have 300,000, you're not keeping 150, you're keeping 138. So the healthy spouse gets to keep quite a bit more. And they get to keep all of their income. So that can be very helpful for somebody if they are the spouse with more income, right? If the healthy spouse does not have enough income to bring them up to about $2,800 a month, they can keep some of the other spouse's income to get them to that level, or potentially all of it, depending on the other spouse's income. So, a healthy spouse still gets to keep quite a bit more than a single person, but that's still a lot of spend down for people. So that's where the concern comes in about equalizing care between the two spouses. So I am a little over time here, but just so you had a picture of what that actually looks like for people. So when we're talking about how do we protect things, it's usually we're more referring to how do we not have it counted as that available asset for somebody. So I don't see any questions, but again, just know that you'll receive some forms in an email, including our common errors when helping Asian parents chart that I referred to earlier, and then also a feedback form where you can let us know if anything we talked about today you'd like to set up an initial consultation on this. Whether or not your parents need documents reviewed regarding the powers of attorney, or somebody does need care soon. Again, we usually set them up for about 2 hours, and then we don't charge you for coming in and having that initial consultation. So if this is a concern for you, I highly recommend it. And then with our topic next week, again, is more on common estate planning myths. So some overlap between these two topics, but a little bit more, for general estate planning misconceptions. And then otherwise, I don't see any questions. So if you have any questions, please sign up for that initial consultation, and I will let you guys go and enjoy the